I mean, literally national publicity, just banging out not guilties after not guilties. And I'm watching these lawyers, I'm like, I'm just trying to work on my art and get people and fight these cases. And I think the way you build it is you get that big case, but you show the world who you are.
Who you are. Lil Durk's lawyer just filed paperwork that got people saying the feds are scrambling like roaches when the lights come on. This isn't rumor talk. This is a real legal chess move that could change the entire direction of the case in Durk's favor fast. Drew Findling, the billion-dollar lawyer, just dropped a motion that basically tells the government, show the specifics or stop the noise. That's not just legal flair. That's a direct challenge to the foundation of the allegations the feds have been floating for nearly 2 years without hard details. The big storyline from the government has been that Durk allegedly orchestrated a murder-for-hire plot against Quando Rondo, including a supposed bounty and directions to accrue. But when Findling asked the basic questions, when did this happen? Where? Who heard it? How much? And what were the exact words? The response has reportedly been nothing but vague summaries without concrete timestamps or quotes. That's where the new filing hits hard. Findling dropped a motion to dismiss for vagueness, arguing the charges are so unclear that Durk can't even properly defend himself. Imagine being accused of a robbery with no store name, no date, no time, and no transaction number to disprove. How are you supposed to defend that in court with precision? This motion doesn't argue feelings. It attacks the case on constitutional grounds, notice and due process. If the government can't tell a defendant what exactly he's alleged to have said, and when he said it, they're asking a jury to make leaps instead of weighing evidence. Findling also spotlights a critical problem. The government keeps focusing on dramatic details around surveillance, stalking, and aftermath visuals. But they're light on proof that Durk actually ordered anything. That's a huge difference legally because the ordering is the core act the government must prove for murder for hire. The filing lays out that the government's supposed bounty theory is missing specifics. No date of the offer, no amount tied to an identified conversation, no named witnesses who heard the exact words, and no record that a bounty was offered at all. If the centerpiece is missing, the entire structure wobbles. And here's the twist. This isn't about being slick with technicalities. It's about forcing the prosecution to play fair and specific. Criminal cases are built on clear facts, not vibes, and that's exactly what Findling is forcing the court to enforce. Here's where it gets even heavier. The government star witness, labeled PW1, has reportedly changed his story multiple times on critical points. And that's a giant problem in any federal case. Juries might forgive small memory gaps, but they do not like flip-flops on the main claim. According to the motion, PW1 first said there was no bounty at all, then said he didn't agree to kill anyone for money, then claimed he acted under duress, and later pivoted to Durk's boy stayed behind in LA to collect and distribute bounty money. That's 4 lanes and 4 turns, and the traffic cam allegedly caught him. Findling points out that the government's own evidence undercut PW1's latest twist. The feds removed that collecting bounty money section from a later indictment, which suggests they realized it couldn't be supported. If the prosecution's main witness keeps rewriting the script, how is the defense supposed to prepare precisely? The motion says it clean. When the government's witnesses keep shifting on crucial facts, the defense is forced to take aim at a moving target, and that's fundamentally unfair at law. Criminal trials are not guessing games. The government has to lock in a theory and prove it with stable, testable evidence. Findling then aims at another weak pillar, the reported effort to lean on rap lyrics as evidence of intent or agreement. He basically told the court, if your case needs art to fill holes in proof, the case has bigger issues than this motion. Music is expression, not a transcript, and courts across the country are tightening up on that. The motion even gives a perfect example of coded language abuse. Imagine the feds keep Durk in the dark about what coded phrase they claim he used. Then at trial, a witness suddenly says, when Durk said the eagle has landed, that means he's offering a bounty for murder. How can a defense team rebut that if they hear it for the first time in front of a jury? That's what Findling calls trial by ambush, and courts don't allow it. Defendants have a right to know the exact statements and the meanings the government plans to argue so they can investigate, cross-examine, and present contrary evidence. This is why the motion is so dangerous to the prosecution's approach. It doesn't just poke at one piece, it exposes a pattern, dramatic storytelling around the scene with thin proof on the command. In law, narrative isn't enough. You need the link. Let's unpack why a vagueness attack is so dangerous in federal court. Because if the court agrees the charges are too unclear, the government must either make them precise or risk dismissal. That's not a small procedural thing. That's a direct threat to the blueprint of the indictment. Findling argues that the government cannot keep things broad on purpose. They can't say a bounty was offered without telling when it was offered, where it was discussed, who heard it, what words were used, and how much was promised. Without that, the defense can't build alibis, test credibility, or challenge interpretations with facts. The motion also checks the prosecution's logic head-on. The government reportedly said the specific words Durk allegedly used are not elements of the offense. Findling answered with a clean legal analogy. A bounty offer is as essential to a murder-for-hire charge as a material misrepresentation is to a wire fraud charge. No offer, no hire, no charge. He also stresses the timeline problem, using a song released 7 months before a specific incident to imply intent for that incident is a stretch. It's like saying a January track about robbing banks proves a person planned an August robbery. It's content, not coordinates. Then there's the grand jury versus trial issue. Findling suggests the government presented one set of facts to get the indictment, then tried to prosecute with a shifting version later. Courts do not like prosecutors changing theories midstream without clear notice and solid evidence to match each turn. Which brings us to the remedy. If the court doesn't dismiss, it can order a bill of particulars, forcing the government to list the specifics, dates, places, quotes, witnesses, amounts, and method of communication. That tool cuts the fog, and if the specifics don't exist, the fog doesn't hide that for long. From a strategy angle, this is offensive defense. Durk's team isn't waiting to react at trial. They're locking the government into a lane right now. Once locked, everything can be tested. Phone records, travel logs, possible corroboration, or lack thereof. And if the government can't meet that burden, reasonable doubt isn't just possible. It's automatic in the face of missing elements. You don't convict on smoke, you need fire that can be traced and measured. Here's what the motion highlights as missing, and it matters a lot. There are reportedly no recordings of Durk ordering a hit, no texts about a bounty, no financial records showing payment, no eyewitnesses quoting the exact offer, and no physical evidence linking him to planning specifics. Without those, the government leans on circumstantial threads and a witness who has changed critical details multiple times, and juries judge credibility first before they weigh conclusions. If they don't trust the storyteller, they won't trust the story. Findling also circles back to geography. Durk wasn't in Georgia when King Von was killed, and he wasn't in LA when another shooting occurred, according to the defense summary. That means the case lives or dies on proving directions given, the when, where, how, and to whom, the core ordering element. If the government can't nail down those direction specifics, they can't tie Durk to the alleged crimes through a conspiracy or murder-for-hire framework. In federal court, he's the guy behind the guy, requires receipts, not vibes. The motion says the government has tried to overwhelm with the drama, stalking footage, photo trails, aftermath scenes, while hoping the jury fills in the planning part. That's a courtroom mirage. It's vivid, but if you walk up to it, there's nothing there. Witness credibility becomes the battlefront. PW1 allegedly went from no bounty to duress to someone collected the money. And then that collection angle was reportedly removed from a later indictment. Every change is a new opportunity for cross-examination and a new seed of doubt for a jury. Findling's play is simple. Force clarity now, block surprises later, and keep the fight on the element that matters most. Did an offer happen, and can you prove it with specifics? If not, the headline charge gets weaker, and other counts tied to it may wobble too. And if the court orders a bill of particulars and the specifics don't match what the grand jury heard, that's another credibility hit to the prosecution's case structure. Consistency matters as much for the state as it does for witnesses. There's a bigger cultural layer here. Hip-hop and the law have been clashing over lyrics for years, and Findling's filing pushes the line forward by telling the court straight, if you need rap songs to stand up your case, your evidence is too thin. That's a message with impact beyond one defendant. From Bobby Shmurda to YNW Melly and others, prosecutors have tried to turn artistic expression into confession, but more judges and state legislatures are warning against it. Findling isn't asking for special treatment. He's asking for real evidence instead of metaphor and performance. The motion also checks the timeline logic, using a track released months before as proof of a specific later bounty stretches intent across time without an anchor. Courts want particulars, dates, calls, meetings, messages, money, and named witnesses who can be cross-examined on what they actually heard. The filing reframes the case away from spectacle and toward elements, offer, agreement, and steps tied to a specific criminal objective. Without those, jurors might be moved by the visuals, but unmoved by the law. From the street's perspective, the defense angle makes sense. Cases often hinge on someone close flipping and telling a story. But when that story keeps changing and the data doesn't match, that's not loyalty versus snitching. That's credibility versus reasonable doubt. Findling's strategy also pressures the process. He's saying the grand jury heard one version, and now the trial theory is morphing without clean notice. That's not just messy. It can be improper if it deprives the defense of fair warning to prepare. If the court grants dismissal or orders a bill of particulars, the government must show exactly what they claim Durk said when he said it, to whom, for how much, and how it ties to any subsequent act. That's where speculation becomes proof, or proof dries up. And even if the case survives pre-trial, Findling has laid down the theme a jury will hear. The government focused on drama where it had receipts and went quiet where it mattered most. That contrast can carry a defense all the way to reasonable doubt. So where does this leave Lil Durk right now? Stronger than last week, because this motion forces the government to put up specifics or risk key charges getting chopped. That's not wishful thinking. That's how pretrial litigation shifts leverage. If the feds can't provide dates, places, words, amounts, and witnesses for the alleged bounty, the centerpiece fades. And without the centerpiece, connected charges start to look shaky too. That's why this filing has the community and legal watchers buzzing today. Even if the judge doesn't dismiss, a bill of particulars could still be ordered. And once those details land, the defense can test each one against phone logs, travel records, device data, witness credibility, and money flow. If it clashes with the prior indictment or doesn't exist, that's defense gold. Juries don't love witnesses who keep changing stories, especially when those witnesses face heavy time and incentives to cooperate. If PW1 gets shredded on cross about versions 1 through 4, the government's bounty thread could unravel in front of 12 citizens fast. This isn't the same as saying the case is over. The government still has resources and time to tighten up, but the burden is on them, and Findling just reminded everyone of that. The defense doesn't have to prove a thing. The state has to prove everything. From a hip-hop lens, there's another takeaway. Defense teams are getting better at pushing back on lyrics and coded language tricks, and this filing could be cited by others fighting similar battles. Art is art, and prosecutors should win cases with evidence, not playlists. For Durk, the path ahead looks clearer. Demand proof, test every claim, and keep the fight on the elements that matter. If the offer can't be pinned to reality, the hire can't stand, and the law is strict about that. Whatever side you're on, the principle holds. Fairness requires specifics, and liberty requires proof beyond a reasonable doubt. That's not a loophole, that's the standard, and it protects everyone when the lights get hot. Drop your thoughts in the comments. Let me know if you think this motion puts Durk on the road home. Smash that like if you value facts over noise, and subscribe with notifications on. I'll keep breaking the real updates as they happen with clarity and respect.